Thanks for joining us today for Jennifer Schaus and Associates in our Webinar Wednesday program. We are coming to you live from Washington, D.C. Our webinars are every Wednesday and are provided complimentary. They are recorded and can be downloaded from our website and YouTube channel, which now holds over 400 of our government contracting webinars. In the interest of time, we do not take questions, so if you have questions for our speaker, we will have her information on the last slide of the presentation today. A special thanks to our educational sponsor, the National Veterans Small Business Coalition, for making these webinars possible. The NVSBC is the largest nonprofit trade association for veterans. Please visit their website for more information. Okay, and now a little bit about us. We work with U.S. federal government contractors, including product, service, and software firms. Our services range from market analysis reports to contract vehicles and compliance. More information is on our website. We also have opportunities for your organization to advertise in our newsletter. We now reach over 21,300 subscribers, and this includes both contractors and government. Contact us for pricing information with the email shown on your screen. As noted, we now have over 400 webinars in our archives. As we continue to educate federal contractors, I would like to bring your attention to our webinar schedule for 2021. The full schedule and speakers are confirmed. First up is a monthly series called the GovCon Live Q&A Cafe. This is a live webinar series held each month. These will take place on the second Friday of each month in 2021 at 12 p.m. Eastern. We have assembled a group of 4 panelists who are subject matter experts in a specific federal contracting topic. The panelists will make a short presentation about the topics listed here on your screen and then take your live questions about that topic. So for example, January will kick off with our panelists covering CMMC on Friday, January 8th. Our panelists include attorneys, consultants, and other industry professionals. You can sign up on our website under the Q&A Cafe tab. Sponsorships are available, and you can email hello@jenniferschaus.com for a media kit with pricing details. Okay, and in our second webinar series in 2021, we will be covering each part of the DFARS, or Defense Federal Acquisition Regulations. Similar to our current FAR series, this will be a weekly series dedicated to defense contracting, its rules, and specific regulations. This series is complimentary and will be held on Wednesdays at 12 p.m. Eastern. We will run through the parts sequentially, which means that we will start the year with DFARS Part 201 and finish with Part 252 at the end of the year. You can sign up on our website under the DFAR tab, and again, sponsorships are available, and you can email hello@jenniferschaus.com for a media kit with pricing details. Okay, and now to introduce our speaker, Devin Hewitt. Welcome, Devin, and we are glad to have you here with us today, and I'll now turn the floor over to you.
Well, thank you. Thank you for having me. As I tell Jennifer often, every lawyer loves a stage, and I'm no exception. I am head of the government contract practice at a firm called Procurement Law in Tysons. I spent my career surveying government contractors, large and small, in the United States and abroad. I have a specialty in bid protest, and I also advise contractors on M&A, transaction agreements such as joint venture agreements, other transaction agreements, subcontracts. And I also advise small businesses with respect to the preferential programs administered by SBA, such as the Women-Owned Small Business Program and the SBDOSB program, among others. I've been asked today to talk about novations. And novations are important in the context of mergers and acquisitions involving government contractors. And if you could go to my first slide, which I believe is several slides in. So what, when, and why are novations and novation agreements, and why are they a topic of discussion in mergers and acquisitions. While mergers and acquisitions involving government contractors is a unique animal, the assets or the transfer of stock in a company is of great concern to the government. There is a statute called the Assignment of Claims Act, and the Assignment of Claims Act prohibits government contractors from assigning their government contracts to third parties. This statute was implemented during the Civil War because it apparently resulted in contractors transferring their contracts and allowing profiteers to take these contracts and take advantage of the government during the war. Now, there are exceptions to the assignment of claims. Probably the most well-known and the most used one has to do with banking and financing. A contractor can assign accounts receivable to a bank as collateral for loans that it takes, and that is a well-known exception. There is also an exception in the case of a government contractor's sale of assets to a third party, and these assets include government contracts. However, in order to avail oneself of the exception under the Assignment of Claims Act, the seller has to seek a novation approval from the federal government. And the reason is obvious. The government evaluates contractors based on bids they submit in response or in participating in a federal procurement, usually in a competitive environment. And in that regard, the government evaluates the past performance, the technical approach proposed by the contractor, etc. And that contractor, if it is the awardee, has been selected as the awardee based on these issues: the scores that it has received for past performance, its technical approach, and its proposed price. So if that contractor, quote unquote, sells its contracts to a third party, and the government now is contracting with that party, the government has no assurances that that party will comply with the proposed price, whether that party, more importantly, has the performance or the past performance that the government relied on, and whether that contractor is responsible. Now, you would say, well, that third party has to comply with the terms of the contract, and that may or may not be the case. It will be required to comply, but whether it does comply is unclear and is a risk for the government. But in particular, the past performance and the quote-unquote responsibility of that offeror is something that is of great concern to the government, as I said, for obvious reasons. Now, that being said, the government doesn't want to stand in the way of capitalism or the free exchange of assets or contracts in the market. So there is this exception to the Assignment of Claims Act, and novation is the way that contracts are transferred subject to approval by the government. So what a novation is the process by which the government agrees to allow Company B, the seller or the transferee, to step in the shoes of Company A, the the seller. Company A is the seller, Company B is the buyer. And novation is an approval of the government, by the government, of the buyer stepping in the shoes of the seller, Company A, and performing the contract previously held by the seller, Company A. Now, what's important to note here, and why novation is such an issue in M&A, is that novation occurs post the transaction. So as a matter of law, as a matter of state law, those assets have been transferred. So they are now owned by the buyer. However, the government does not recognize that transfer. And so the government will only recognize the transfer through the novation process. That means in order for the buyer to get the benefit of its bargain, to get the asset for which it has paid, it has to have the government novate the contract. But it will only get that after it has paid for the asset. So novation is most likely the primary risk that a buyer has in the M&A process. Now, that is not a risk that is associated with a stock transfer. The government does not need to approve, generally speaking, the purchase of stock by a third party because the company still exists and the company still holds the contract. However, that is not always the case if there is a stock purchase with regard to a small business. Recertification is required for small businesses, particularly Section 8A businesses and other businesses that depend on a certain status after the change in ownership. So while there isn't a novation concern, there is a concern about the value those assets will have to the buyer if the buyer is not a Section 8A or a disadvantaged minority that the SBA approves to step in the shoes of the 8A contractor, or if it is not a small business and it acquires small business contracts, and the issue is how long will it be entitled to the revenue from those government contracts. So in a stock sale or purchase, novation is not an issue. However, where there is an asset sale, where the contracting party for the government by law is no longer the entity to which the government awarded the contract in the first instance, novation is required. Next slide, please. So a novation agreement is the document that is signed by the government, Company A and Company B, and that agreement represents the government's approval of the transfer of the contract from Company A to Company B. So again, what's significant here is all three parties execute the novation agreement. So all three parties, well, more importantly, Company A and Company B, both have obligations under the novation agreement. So Company A, the seller, doesn't get out of the contract. We'll talk about what the obligations of Company A or the seller are in the novation agreement, but it isn't as if Company A washes its hands of the contract once these are transferred and once the government approves the transfer. Again, if the transfer is not completed and recognized by the government will look to the seller until that novation agreement has been executed. As I mentioned before, the novation agreement is executed after the acquisition has been completed as a matter of law, notwithstanding the fact that the buyer now, as a matter of law, has the contract and most often has the employees as well along with those contracts. So that is, as I said, the biggest risk in an M&A transaction. Next slide, please. Now, when the government considers a novation, and what happens is that once the novation is completed, the seller has to submit a novation request to the contracting officer that holds the contract in most instances. And the government approves the novation and then subsequently signs the novation agreement. And there are a number of reasonable considerations the government will review in deciding whether or not to approve a novation. The most important thing is to determine whether or not the transferee, the buyer, has the financial capacity and other necessary resources to perform the contract. So, is it large enough? Does it have the revenue enough? Is it quote unquote responsible, as that term is used in government contracts, such that there is a minimal risk that that company will disrupt or default on the contract? And other resources are other things that are not really financial, and whether that's employees or machines, material, facilities, etc. So that's of concern to the government, number one. Again, another concern, responsibility, as many of you know, is a term that's used in government contracts to mean whether or not the contractor to which the government is considering awarding a contract has various characteristics that make it suitable as a contractor for the government. And those are financial. Those are whether the contractor has the necessary resources and capacity. And it is also other issues such as ethical, whether that contractor is on the suspension or debarment list, whether that contractor is current on its taxes, etc. There also may be issues with it being a small business and the access to capital, although ultimately that is something that SBA decides under a certificate of competency procedure. The next consideration the government will review is whether or not the sale or acquisition of the contract was quote unquote legal. And, that simply means, was it accomplished and in accordance with the governing law? They want to make sure that that transaction has been completed, that there are no issues that the government will encounter from a legal perspective should it go ahead and substitute the buyer or the seller in the government contract. As a result, the government asks for there to be a legal opinion submitted by a lawyer on behalf of both the seller and the buyer, confirming that the transaction was accomplished and according to law. Another issue that is very important from the government's perspective is what can it do to mitigate the risk if the buyer fails to perform or performs poorly. The government can review these considerations we've talked about: financial capacity, resources to which that contractor is able to access, whether it's ethical, and whether the transaction was legal. It can do its best to do its due diligence on those issues. But what happens in the event the contractor performs poorly? If the contractor performs poorly for the reasons that we've just discussed, let's say, for example, financial, then the government may not have any recourse or plan B if that happens. So this is the environment in which the government will consider a novation request, and these are the concerns that both the buyer and seller should identify and review with each other as they approach negotiating the acquisition agreement, or what is often known as the asset purchase agreement. Next slide. Now, as I've said, the seller needs to submit a novation request to the contracting officer. And the novation request is really a novation package. It includes a lot of materials and documents that the government feels it needs in order to make the decision of approval, and those documents address those considerations that I've just reviewed. So the novation is supposed to be made, as I indicated, to the contracting officer. However, for the contract that is going to be transferred. However, if there are a number of contracts that are going to be transferred in a particular agency, and this may be the case for very large companies, SAIC, Leidos, etc., then the novation request has to be submitted to something called the ACO, the Administrative Contracting Officer. The Administrative Contracting Officer is the one that will administer those novations on behalf of the agency. But if there are just a few contracts and just a few contracting officers, the request can be made directly to the contracting officer. Now, what is going to be included in the document, or in the document package, rather? The package has to include the signed novation agreement. And the provisions in the novation agreement are actually prescribed in the Federal Acquisition Regulation. So there is a sample novation agreement in the FAR. Obviously, most contractors try to use that template as much as possible and try to avoid deviating from that template as much as possible because, as we all know, the government likes things to be straightforward and not creative in any way. However, the FAR does authorize changes to the novation agreement. It's just a suggested template, so it's not required to use that agreement, although that's generally the launching point for the parties that have executed an asset purchase agreement. Also included in the novation package is the asset purchase agreement. That evidences the transfer of the assets, and the asset identifies the assets that have been transferred. The novation package has to identify the contracts and often has to include the contract, or for ease and convenience of the government. The buyer has to include or provide the seller to include in the package its evidence of its ability and capability to perform, and that can take a number of different ways to do that. One way is that it actually has to submit its balance sheet to show it has that financial capacity to perform. So the novation package will be confidential, or at least it will be labeled as confidential, but often the parties are a little bit hesitant to open the kimono, if you will, to their finances. But that is something they are going to have to do to be able to demonstrate to the government that it can perform the contract. And from the government's perspective, that's a reasonable request. So as a result, the balance sheets of Company A and Company B must be included in the novation package, as well as additional evidence of capability to perform if that is required. And that could take the form of offer letters to key employees, or the facility, and particularly in cleared contracts, whether there is a skiff, etc. There are other issues that may be addressed in the novation package that might be unique to the particular context or circumstances of the acquisition, and the contracting officer likewise may ask for additional documentation. But in the first instance, the package has to be submitted with, at a minimum, these documents. And indeed, the FAR does list the documents that are typically included in a novation package. Other agencies also may publish on their website or may make available to contractors the documents they look for that may be in addition to what is required in a straightforward novation package. For example, GSA, that administers the GSA schedules, will require additional information, and the information that is required in that instance is similar to the information that the current awardee has had to submit to the agency, such as comparable pricing, most favored customer rates, etc. So the extent and the work involved with submitting a novation package is substantial, and it can vary from agency to agency. And for example, if these are classified contracts, the buyer is probably going to have to produce additional evidence of its capability to perform in that environment. Next slide. Oh, and one more thing to address the additional concern I talked about whether or not the novation has actually been done as a matter of law. As I mentioned earlier, also in the novation package, there has to be opinions, legal opinions by counsel indicating that the transaction has occurred as a matter of law. The companies also have to demonstrate that the companies have received authorization to engage in the sale or the acquisition. And that means if the companies are corporations, for example, there needs to be a demonstration of board resolutions authorizing the acquisition or the sale. And if it's an LLC, some other type of evidence that the members of the LLC or the managing member has authorized the transaction. So there are many documents from a legal perspective that have to be created or provided, again, to ensure for the government's perspective that everything is legal, that things will be as smooth as possible after the transition. Now, what is included in the novation agreement? And this is, again, it's a unique animal. And a lot of parties don't understand that these are going to be obligations that the government believes are necessary. And they're obligations that are sometimes difficult for a buyer or a seller to accept. Now, Company B will assume the buyer will assume all the company's obligations and liabilities under the transfer contracts. That is a little bit different than some standard M&A transactions because often an acquirer doesn't want to assume the stock of a company because then for sure it will take not only the obligations of that company but all liabilities of that company. An asset purchase provides more flexibility in the negotiation of that transaction, and sometimes under certain conditions, the buyer will take the assets but not all the liabilities, or will only take the liabilities for a certain, capped amount. But with a novation, Company B has to assume all the seller's obligations and liabilities. Company A waives all rights against the government under the contract. So that means that there are any claims or outstanding issues, requests for payments, etc., that are between the government. The seller doesn't retain those. It doesn't maintain or doesn't have the right to get any benefit from those preceding claims or outstanding receivables, etc. So the seller has no rights against the government once the novation is executed. Now, the reverse isn't true. The government does not waive any claims it may have against Company A that are outstanding at the moment of novation, or those claims that may arise after the transfer of the assets or after the novation. So while Company A can't go back and get what it believes it was entitled to, its entitlement to anything from the government has been waived, it still may be liable to the government for some performance that has occurred prior to the acquisition or novation, even though those liabilities may have been transferred in the asset purchase agreement as a matter of law. So that inconsistency has to be addressed in the asset purchase agreement. Another unusual obligation that is in a novation agreement is that Company A, the seller, guarantees performance of the transferred government contracts and payment of any liabilities associated with the transferred contracts. So as I mentioned earlier, the government doesn't waive any claims against Company A, the seller, notwithstanding that as a matter of law, the seller no longer holds the contract. And if anything goes wrong, the government can look to Company A to do something to ensure the performance or pay any penalties or default notices, etc., that the buyer experiences once it starts to perform those contracts. Finally, another unique provision of a novation agreement is that the buyer ratifies all prior acts of Company A, the seller. So Company B, once it's in the shoes of the seller in those contracts, can't say to the government, well, I'm not going to be bound to this because I didn't agree to it. The seller agreed to it. The government is not going to accept that excuse. Once those assets have been transferred, consistent with the agreement that the buyer assumes all obligations and liabilities under the transferred contracts, the buyer also ratifies all prior acts. That means it assumes and approves all prior acts of the seller. Now, this may have unique consequences, and indeed, I was recently involved in a deal where this came up. I represent a small business that acquired assets from another small business, and that small business held several contracts. And the acquisition went through smoothly. The contracts and the employees and any other ancillary assets associated, such as computers or papers, etc., goodwill, which is also an asset. All that was transferred pursuant to the asset purchase agreement, and the government, in fact, novated the transfer, novated the contracts to the buyer, which was my client. The buyer then, my client, undergoes a standard GSA audit. One of the contracts that was transferred was the GSA schedule contract held by the seller. And indeed, that was a key asset for the buyer. So the buyer now has the GSA schedule contract. It's had it for 6 months. So requirements under that contract, under various task orders, is to provide personnel. So it continues to do that using the staff of the seller, who were familiar with the GSA contract and were transferred, quote unquote, under the asset purchase agreement. So 6 months later, it begins to respond to a standard GSA audit under the GSA schedule contract. And part of that is the government request to look at various resumes to determine whether or not there was any quote unquote unqualified labor that was submitted. And unqualified labor in this context means that the contractor has provided resumes to the government under a certain labor category, but has charged the government under one of its labor categories in the GSA schedule contract, but the qualifications identified in that GSA schedule labor category don't match the labor category under the contract. And typically speaking, the concern comes up when a less qualified candidate is submitted, but the charges the government pays are for a more qualified candidate. And that's called unqualified labor. So as my client is reviewing resumes to respond to the GSA audit, it discovers that certain of the resumes of individuals that are performing task orders under that GSA schedule contract don't match the LCAT category. And the LCAT category rates are those that have been charged to the government. So it becomes concerned. And it's concerned for a number of reasons. One is that the government subsequently has, and therefore has overpaid for those personnel. And secondly, contractors are under something called the mandatory disclosure rule. And if they have any evidence or clear evidence that they have overcharged the government or there has been some potential instance of fraud, they have an obligation, a mandatory obligation to disclose that to the government. And if it turns out that there's a discovery that that has not been done, a contractor can not only be debarred, suspended or debarred, but may suffer civil penalties and maybe criminal penalties under the False Claims Act. So it's a fairly serious thing. So my client went under an investigation, and it engaged me and a company that works with contractors on GSA schedule contracts and audits. And we investigated, and we discovered that this unqualified labor issue was happening before they acquired the seller's contract, and that the seller had done this for quite some time, but had never been discovered by the government. It was only during the GSA schedule audit by my client did they discover this. So the unqualified labor was going on for years. And because of the novation rules and the novation agreement that the client executed, the client was liable not only for the unqualified resumes that it submitted on its watch, quote unquote, but also for the unqualified resumes that were submitted by the seller. And these can have penalties of 3 times the actual damages the government suffered. So it was, it suffered incredible exposure. We did disclose to the government, and now we are attempting to negotiate the settlement based in part on our cooperation and the fact that this happened post-acquisition, and we did do our due diligence, but there is some evidence that prior conduct had been hidden from our client, my client, who was the buyer. But anyway, that just illustrates how dangerous acquiring a government contractor can be, and why due diligence is probably the second most important risk area for acquisition of government contractors or acquisition of assets of a government contractor, because the seller takes all liabilities of that prior seller and ratifies all the acts of the seller and can't disavow itself of any of those actions, which, as I've just suggested, have significant consequences. Next slide. So here are the key issues in novation. The execution of a novation is completely discretionary on the part of the contracting officer. What typically happens is that novations are submitted to the contracting officer or the ACO, and then the contracting officer typically just shifts it to the in-house counsel to review and sign off on all the legal issues. Now, that's not true for all contracting officers. There are some contracting officers that are vested in the contractors, vested in the people that are performing the work, that may have a great experience or not so great experience with the seller. And so contracting officers can insert themselves in the process and can make that process either smoother or not so smooth. Ultimately, the legal documents in a novation package are probably up to snuff because the lawyers typically know what they're doing. There is a template, and corporate lawyers routinely engage in M&A agreements. So the review by the lawyers really not too difficult. From the lawyer's perspective, the client for that lawyer in an agency is the CO. And so the CO needs to be made happy. Now, as I said, often COs simply see this as an administrative issue, and they give it to the legal, and once the legal signs off, they're okay with it. But other times, there may be an issue, or the CO may want to get involved, and that may be a concern. Now, one of the issues that comes up in these novation agreements is what actually is being transferred. Often, the fact of the matter is that contractors want to buy the contracts that another company holds. And that's really the only asset they want. They don't want the contractor's cars or desks or, its other commercial contracts. What it really wants is those contracts and the ability to get revenues under their contracts, particularly if that company bid on those contracts or otherwise wasn't eligible to bid for that particular period or wasn't aware of the existence of those contracts. So usually what they want is the contract. But the assignment of claims prohibits the transfer of contracts. The exception for the assignment of claims prohibition is the transfer of assets subject to an asset purchase agreement. So you run the risk, if you only transfer contracts, that the government will see that and say, no, we can't approve just the transfer of contracts. You have to transfer the seller's assets. So the challenge is, particularly when there is a contract under which the seller is not yet performing, or if it's an IDIQ contract and the seller has yet to receive a task order, to show that actual assets are coming with the contract. Now, one easy thing most contractors seize upon in this context is employees, and say, well, the major asset of a professional services contract is the employees. But if you think about it, employees aren't materials or goods. You can't transfer employees as a matter of law. All the buyer can do is offer employment agreements or employment to those employees that are currently performing the seller's contracts, and presumably most employees will take them up on that offer. But that may not be the case. It may be that the buyer has a bad reputation, or the benefits offered by the buyer aren't particularly good, or the work is going to be done at the contractor's facility, is not on site, and that requires the employees now to have a longer commute. So the transfer of employees is a little imaginary from the part of the seller and buyer, but more importantly, on the part of the government. Now, some contracting officers and lawyers are very aware that you can't transfer employees, and therefore that's an issue. Others, believe that employees are indeed an asset. At a minimum, other things can transfer if they exist. IP, some materials, whether that's laptops or, accounting systems or, sometimes a lease, maybe. There's also something as goodwill, which is sort of a fiction about the reputation that a contractor has that may follow the work it does under a contract. And there, one issue there is also the ability to get past performance if you acquire those contracts. So that is something every contractor has to consider. And most contractors aren't aware of the distinction between a transfer of contracts and a transfer of assets. And again, the biggest risk that I mentioned was that an agency will not consider or approve a novation until the deal has been closed. So the scepter over this transaction is, what is the company agree, for a variety of reasons. Well, the transaction documents need to address that. So they have to address the risk associated with the CO approval or disapproval. The transaction documents also have to address performance during the period within which the novation request is pending. Novation requests are not immediate, and they can take months to years, depending on the contract, the busyness of the contracting officer, the interest of the contracting officer, etc. But as a matter of law, the assets have been transferred. So the seller, who is still in privity with the government, who from the government's perspective is still accountable to the government, no longer has the employees and no longer has the assets. So what typically is done in that situation is that the buyer performs as a de facto subcontractor to the seller. The seller gets the revenues and payments for such performance and acts as a pass-through on those payments to the subcontractor who's the buyer. But that's got to be arranged for prior to the time. And the transaction most likely will include indemnities regarding performance, because of course, per the novation agreement, the seller is still on the hook. So the seller, in order to mitigate its risk from the novation agreement, will likely want to go back to the buyer and say, if it turns out you default on this contract, then you owe me the cost I incur trying to make good on that contract with the government, which I'm required to do under the novation agreement. So there are indemnities that have to be included, and then there's negotiation of caps on those indemnities. And given that the buyer must execute those indemnities, then there are issues of due diligence that's incumbent on the buyer to ensure that the contracts it acquires are going to be something that it can perform and indeed are worth the money that it's paying. Now, how can you mitigate some of these risks? Well, one of the issues I just talked about was indemnities. The other issue I've just talked about is a subcontract. However, sometimes the hardest risk is and the biggest risk is the CO declining the approval necessary for the buyer to get the benefit of what it's paid for. What we suggest for clients to do is to quote unquote socialize the deal with the contracting officer ahead of time, to make them aware that this is something that may occur and to assuage any concerns up front that the contracting officer may have. And typically, there'll be some signs from the contracting officer, either that the contracting officer is sophisticated with this process, has seen it, understands that it's a regular part of capitalism, that the government's not supposed to stand in the way for it, and it'll just be a matter of administrative checking the box. But sometimes the contracting officer will respond with a deer in the headlights look, indicating that it doesn't understand what it is, and suddenly all it feels is, danger, danger, danger. I may be involved in something that's going to expose the government, and I better, for lack of a better term, cover my ass, which means that it may be difficult. And then there are other issues that I've raised before. The CEO, doesn't like the seller and wants to make it hard for them, or doesn't like the buyer and wants to make it hard for them. So, there are a number of issues that could be socialized early as part of the due diligence of the buyer. And finally, there are other risks that are associated with acquiring a small business, and particularly a small business that has a certain status. You can't just transfer 8A contracts because participating in the 8A program is something that has to go through all kinds of eligibility hurdles. And the government, or SBA, is not going to allow one disadvantaged individual, quote unquote, just to jump into another disadvantaged individual's shoes. So you're going to have to get SBA approval for that. There are also recertification requirements after there has been an asset acquisition. So the new contractor must recertify its size or its status as a woman-owned small business. Now, the Small Business Administration's regulations allow and say that if a contract is acquired by a large business and therefore that contractor is no longer a small business after the novation, that it will be considered a small business for the remainder of the contract period, but it will have to recertify in the 5th year if it's a long-term contract, or it'll have to recertify if it competes for the follow-on But in most cases, the agency won't have an issue with that. What they may have an issue with, though, is that they may not be able to take credit of the revenue that comes under that contract that they apply towards their small business set-aside goals. So that may cause them not to exercise a certain option. Again, this is another issue that should be socialized with the contracting officer prior to a novation request, and with any other parties like SBA or a company's business opportunity specialist. So in conclusion, there are a lot of moving parts, and novation is critical for the success of any M&A transaction. And it's unusual. It is not something that happens in the commercial context. It's something unique to government contracts, and it presents considerable risk, which affects the value and the structure of an acquisition of either a contract or a contractor. So this is something that it's well worth contractors to look at even before they start considering acquiring or approaching a target. Thank you very much. And again, as said earlier, feel free to reach out to me if you have any further questions. I appreciate your time.
Thank you so much, Devin, for a great presentation and sharing your time with us today. And thank you to everyone who joined us for this webinar. And the recording will be on our website and YouTube channel within the next 24 hours. So just look out for that. Stay safe, and please join us in the new year during our GovCon Live Q&A Cafe series and our DFARS webinar series.